Yes, Trump finally won a popular vote. 12 citizens of New York unanimously found former President Donald Trump guilty of all 34 felony counts. He reacted about as you would expect.
This was a rigged trial by a conflicted judge who was corrupt.
It's really unfortunate that Trump has been a victim of a rigged election, rigged impeachment, rigged federal judicial system, rigged state civil judicial system, and now a rigged state criminal judicial system as well.
Remember, folks, it's a rigged system.
Yeah, cry more, Donnie. Chaos lawyer and reluctant Trump whisperer Liz Dye has the details.
Thanks, Devin. Well, it finally happened. For the first time in our nation's history, an American president was found guilty of a felony in a court of law. Although if you ask the future felon himself, that was inevitable.
Mother Teresa could not beat these charges.
Well, yes, if Mother Teresa had gotten her fixer to pay a porn star to keep quiet in the run-up to an election, then covered up the payment through a series of false invoices and checks, she too would probably have been found guilty of 34 felonies. But if Mother Teresa ever did do any of that, she managed to keep it on the down low. Trump, however, is not a keeping it on the down low kind of guy. At the celebrity golf tournament in 2006, where the encounter allegedly took place, he managed to get his picture taken with Stormy Daniels, the adult film actress who had been sent there to represent her production company, Wicked Pictures. And he reportedly boasted about their brief sexual encounter the next day. But 10 years later, when he decided to run for president, he was decidedly more circumspect. Trump, whose notorious philandering had been a subject of the New York tabloids for decades, suddenly had to sell himself to evangelicals as a faithful family man who just so happened to have 5 children by 3 wives, and to have appeared in a pornographic video, and to have bragged about wandering into the changing room while beauty pageant contestants were getting dressed. And so he enlisted his longtime friend David Pecker, the owner of the National Enquirer, to burnish his image. Pecker, who was the first witness at the trial, testified that just days after Trump announced his candidacy, he was summoned to a meeting at Trump Tower where Pecker promised to help Trump's campaign by publishing positive stories about Trump, negative stories about his opponents, and alerting him through Michael Cohen when Pecker came across damaging information, particularly regarding women. Pecker brought up 2 stories, including one from Playboy model Karen McDougal, who was paid $150,000 for her account of a relationship with Trump a decade earlier. Pecker testified that he'd buried stories for other celebrities before and even for politicians. But his lawyers convinced him that selling McDougal's story to Trump might look like a campaign finance violation, so he refused to go through with it. Then, Stormy Daniels came forward, and Pecker testified that he refused to pay her out of fear that the association with an adult film star would upset Walmart, the National Enquirer's biggest distributor. And even after Cohen threatened that the boss would be furious if he didn't do the deal, Pecker wouldn't budge. So Cohen negotiated to pay Daniels $130,000 to sign a non-disclosure agreement, aka an NDA. Except that Trump kept putting the deal off in hopes that he could delay until after the election and avoid paying her altogether. Then on October 7th, 2016, the Access Hollywood tape dropped, with Trump bragging about grabbing women by the genitals because...
And when you're a star, they let you do it. You can do anything.
Trump's aide Hope Hicks testified that the tape went off like a bomb inside the campaign, knocking a Category 4 hurricane out of the news cycle, at which point Trump told Cohen to make that deal with Daniels happen, and he didn't care how, because Stormy Daniels telling her story in the press would be the end of his presidential campaign. So Cohen borrowed $130,000 against his house and put together an NDA for David Dennison and Peggy Peterson to sign, where they all agreed never to speak about the matter again. And on November 1, the agreement was signed and Trump went on to win the White House. During their opening statement, prosecutors revealed that on election night 2016, Daniels' lawyer Keith Davidson messaged Dylan Howard, then the editor-in-chief of the National Enquirer, asking, "What have we done?" Howard replied, "Oh my God." Howard texted a family member speculating that maybe Trump would pardon him for electoral fraud, which strongly suggests that everyone involved in the Daniels payoff thought that their schemes had put Trump in the White House, and they strongly suspected that what they had done was against the law. Michael Cohen, who had hoped for a job in the administration, perhaps even as White House chief of staff, soon found out that he was going to be fobbed off with the title personal attorney to the president and very little else. And while that honorific allowed him to pitch himself as a sort of lobbyist, it didn't come with a paycheck. In fact, the Trump Organization actually cut his Christmas bonus that year and kicked him off the payroll in January of 2017. By December, Cohen was furious that he hadn't been repaid the $130,000, and he even prevailed upon Pecker to intervene with Trump on his behalf, which Pecker did, and according to his testimony, Trump said, don't worry about it, I'll take care of it. And the way that he took care of it was through a series of monthly checks for $35,000, supposedly paying Cohen for legal expenses.
I don't know, this all seems really complicated. Legal fees, reimbursements, taxes. If only there was someone who were really good at explainers.
So at the trial, Trump Org Comptroller Jeffrey McConney was shown Exhibit 35, a bank ledger documenting that Michael Cohen had wired $130,000 through an LLC to Stormy Daniels' lawyer, Keith Davidson. So that was the payment to Daniels, $130,000. On the ledger, though, there were also handwritten notes, presumably by Cohen, adding $50,000 to the tally for money paid to a company called Red Finch to rig an online poll that CNBC was running on the most famous businessmen because Trump was frustrated that he was in 9th place. So that brought Cohen's out-of-pocket expenses to $180,000. Now on the left side, there were notes by Trump Org CFO Alan Weisselberg documenting that they would have to gross up the payment to $360,000 to account for the fact that Cohen would owe taxes because he was calling it income to keep the reimbursement secret. If it were publicly a reimbursement, the money would come into Cohen and then out, and he could call it an expense and wouldn't be taxed on it. But because they were going to be keeping it a secret, he would have to declare that as income. And then on top of that, they added a $60,000 bonus, presumably just because, like, at this point, Cohen knew a lot, so they should keep him happy. So now that's a total of $420,000. And if the payments were going to be paid out in $35,000 increments, that'd be like 12. That'd be 12 equal payments, and that's what there were. This isn't complicated math.
Exhibit 36 was McConney's own notes from the meeting, confirming that the $180,000 would be doubled for taxes and wired monthly from DJT in increments of $35,000. He even included a helpful note that Cohen would be removed from the Trump Organization's payroll in January of 2017, after which Mike was to invoice us that $35,000 a month, which he did. And to top it all off, these notes were on Trump Organization stationery because none of these geniuses had ever heard of the Stringer Bell rule.
Is you taking notes on a criminal fucking conspiracy? What the fuck is you thinking?
At the trial, Trump's lawyer Todd Blanche argued that Cohen had actually been doing legal work in 2017 to earn those monthly payments. In his closing argument, he made the bizarre claim that Cohen secretly paid off Daniels as part of a plot to take advantage of Donald Trump. Quote, he made a decision to pay that $130,000 to Ms. Daniels. He didn't tell President Trump about it. He wanted to do it because he knew that he could get credit for doing something to supposedly help President Trump at some later time. Whether they won the election or lost the election, he would be able to get that credit. And that might have been persuasive if the prosecutors were simply asking the jury to take Michael Cohen's word for it. After all, Cohen was convicted of tax fraud and lying to Congress. He's hardly a credible character. But it wasn't just Cohen calling it a reimbursement for the hush money payment. David Pecker testified that he had also leaned on Trump to pay Cohen back. And McConney confirmed that he took Cohen off the payroll and routed those invoices through bookkeeping rather than through the legal department. Exhibits 35 and 36 showed that the Trump Organization's bean counters were doubling the debt to cover Cohen's tax liability, and Hope Hicks practically laughed on the witness stand when prosecutors asked if she thought Cohen was the kind of guy to secretly make a $130,000 payment to Stormy Daniels out of the kindness of his heart. She said, I didn't know Michael to be an especially charitable person or selfless person. He's the kind of person who seeks credit. There's also the fact that Trump tweeted repeatedly that he'd reimbursed Cohen for the Daniels payout. And not for nothing, but Rudy Giuliani, Trump's own lawyer, admitted it on air back in 2018.
So they funneled it through the law firm. Funneled through the law firm, and the president repaid it.
Trump's current lawyer, Todd Blanche, countered by calling Michael Cohen a liar over and over and over again at high decibel. He said, it's like what people talk about with athletes like Michael Jordan is the GOAT, Tiger Woods is the GOAT, Tom Brady is the GOAT. These athletes are the greatest of all time, the best among their peers. Michael Cohen is the gloat. He's literally the greatest liar of all time.
Stop it. Get some help.
Assistant District Attorney Joshua Steinglass, who delivered the 6-hour closing argument, said, keep something else in mind when the defense goes on and on about how Michael Cohen is immoral, or he's a liar, or he's a thief. Mr. Blanche actually said, this is not the type of witness you want. We didn't choose Michael Cohen to be our witness. We didn't pick him up at the witness store. The defendant chose Michael Cohen to be his fixer because he was willing to lie and cheat on Mr. Trump's behalf, which is a slightly better joke. Plus, Steinglass had all those exhibits and witnesses to back up what Michael Cohen said.
Well, the jerk store called. They're running out of you.
In the end, it took the jury of 7 men and 5 women less than a day and a half to reach a guilty verdict.
Now, throughout this trial, Trump was represented by Todd Blanche. But if you want a good lawyer, my law firm, the Eagle team, can help. If you've suffered a data breach, especially if you got one of those data breach letters saying that your information might have been leaked, if you were involved in a car accident, or have dealt with sexual harassment from Trump or anyone else, we can represent you or help find you the right attorney. It's so important to talk to a lawyer right away so you can get the best representation and find out what your options are. So just click on the link in the description or call the number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. The link is down below.
Each check, ledger entry, and invoice related to Cohen's monthly payouts was charged as a separate count, which is how Trump got indicted for 34 counts of falsifying business records in the first degree under New York Penal Law Section 17510. But 17510 is a felony charge that derives from first-degree falsifying business records, which is a misdemeanor. So under 17505, it's a misdemeanor to make or cause a false entry in the business records of an enterprise. And under 17510, it's a felony to make a false business record with the intent to commit another crime or to aid or conceal the commission thereof. In plain English, if you create the false business record as part of a criminal scheme, then it becomes a felony. And look, no one in that room believed that Michael Cohen was being paid $35,000 a month for work performed in 2017. The misdemeanor false business records were pretty much a given. So for the purposes of this case, the main thing that prosecutors had to do was come up with another crime that would plus up that misdemeanor false business record to a felony. And in fact, they came up with three. First, and most obvious, is tax fraud, because everyone understood that the object of this game was to have Cohen file a false tax return claiming that he'd earned $420,000 for work performed when he was actually being reimbursed for what was functionally a loan to the campaign. The second crime was a violation of the Federal Election Campaign Act, or FECA, because in 2016, when Cohen paid $130,000 to Daniels, the maximum an individual could donate to a campaign was about $2,700. And while Cohen didn't write the check to the Trump campaign, he did write it for the benefit of the Trump campaign. And that still counts. So if Cohen had, say, hosted a party for the campaign and paid $10,000 to the caterer, it would still be an excessive campaign contribution, and this is no different. Trump's lawyers tried to argue that Trump wanted to silence Daniels to protect his family from embarrassment, not for political ends. But that was pretty fatally undercut by Pecker's testimony that Trump invited him to a meeting at Trump Tower just days after announcing his candidacy. At the meeting, they cooked up a plan for the National Enquirer to bottle up stories that damaged Trump while attacking his rivals. The whole purpose of this plan was to protect the campaign. Trump never cared about buying Stormy Daniels' silence between 2006 and 2016, and if he'd never run for president, it would have stayed that way forever. And so the prosecutors argued that money Cohen had paid to Daniels was an undeclared and excessive campaign contribution. The third predicate was a violation of New York election law, section 17152, which makes it a crime to conspire to promote or prevent the election of any person to public office by unlawful means. And here's where things get a little wonky, because the prosecutors suggested that the unlawful means were the tax fraud and the campaign finance violation. So in some sense, this thing kind of loops back on itself. Once they defined the crimes, the prosecution had to prove that Trump had the intent to commit them. The judge instructed the jury that a person is guilty of falsifying business records in the first degree when, with intent to defraud that includes an intent to commit another crime or to aid or conceal the commission thereof, that person makes or causes a false entry in the business records of an enterprise. So under New York law, the prosecution had to prove beyond a reasonable doubt that Trump both committed the business records offense and that he intended to commit one of the three other offenses. The prosecution didn't need to show that he committed the other three offenses, though. And it gets even wonkier because the jurors didn't have to agree on which of the three other crimes plussed it up from a misdemeanor under 17505 to a felony under 17510. The jury instruction said, in determining whether the defendant conspired to promote or prevent the election of any person to a public office by unlawful means, you may consider the following. 1. Violations of the Federal Election Campaign Act, otherwise known as FECA. 2. The falsification of other business records, or 3, violation of tax laws. So, 4 of the 12 jurors could believe that the other crime was tax fraud, 4 could buy the FECA violation, and 4 could be convinced by the nesting doll of the New York State election crime. And that would be fine. In fact, no one will ever know which predicate they accepted, or even if this was an issue at all for the panel, since there was no place on the charge sheet for the jurors to specify which other crime they were basing their verdict on. And it may seem odd, but that's just how New York law works. which Trump's lawyers explicitly acknowledged during the charging conference when they negotiated those jury instructions. Trump wanted the judge to say, you, the jury, must reach unanimous decision regarding whether the people have established unlawful means, and if so, which unlawful means was or were at issue. And Justice Merchan said, do you agree that unanimity is not ordinarily required? To which Trump's lawyer Emile Beauvais replied, certainly, but we think it's important under the circumstances of this case and think it's in your Honor's discretion to make clear the record here. In other words, he said, I admit that I'm asking you to make an exception for my client and the decision to do so is within your discretion. But the judge said, what you're asking me to do is change the law, and I'm not going to do that. And that was that. This will not be an issue that gets the case overturned on appeal, but it will be an issue that sucks up a lot of airtime. In fact, it already is. Donald Trump got the ball rolling earlier in the week with a post on Truth Social claiming that the reason the radical, highly conflicted judge Juan Merchan had to come up with 3 fake options for the jury to choose from without requiring them to be unanimous, which is completely un-American and unconstitutional, is because the corrupt Soros-backed DA, Alvin Bragg, couldn't come close to proving that any crime was committed. Soon, all of Trump's MAGA allies were singing from the same hymnal. Senator Marco Rubio tweeted that judge in Trump case in NYC just told jury that they don't have to unanimously agree on which crime was committed as long as they all at least pick one, and that among the crimes they can pick from are ones Trump wasn't even charged with. This is exactly the kind of sham trial used against political opponents of the regime in the old Soviet Union. Simmer down, little Marco. Fox News' John Roberts tweeted that Judge Merchan just told the jury that they do not need unanimity to convict. 4 could agree on one crime, 4 on a different one, and the other 4 on another. He said he would treat 444 as a unanimous verdict. Here's Trump's favorite legal commentator, Jonathan Turley, a professor at George Washington University Law School, explaining on Fox that no one knows what the crime is.
When they were reading those guilty verdicts, the one thing that we didn't know is really what he was found guilty of. Because if you remember, the judge allowed the jury to find guilt on any one of 3 secondary crimes. We weren't told whether the jury found any one of those crimes, whether they found all 3 of those crimes. I'm not too sure we will know that.
That's just not true. Donald Trump was convicted of creating a false business record to cover up an illegal campaign contribution made to influence the outcome of the 2016 presidential election. Unanimity as to the predicate is not required under New York law, as his lawyers acknowledged in open court. But perhaps the former president can be forgiven for his failure to understand the vagaries of New York criminal procedure and precedent. In fact, this whole thing has been a learning experience for him. He was shocked and chagrined to discover that the prosecution, which has the burden of proof, gets the last word. Early in the week, he posted on Truth Social, "Why is the corrupt government allowed to make the final argument in the case against me? Why can't the defense go last? Big advantage, very unfair, witch hunt DJT." After closing arguments, he stood next to his lawyer Todd Blanche and claimed that the prosecutors rigged the case by failing to call important witnesses.
But a lot of key witnesses were not called. Look at your list. Look at the players. And you know who I'm talking about. You can take 5 or 6 of them. Why didn't they call those witnesses? They didn't call them because they would have been on our side.
Blanche said the same thing, but dumber, on CNN.
We never saw Keith Schiller, Alan Weisselberg, some key figures here who got brought up a lot. Why didn't the defense call any of these witnesses?
Well, because we happen to live in America and we don't have the burden of proof. And so there's not... That's not the point. That's a question that is a loaded question that should not be asked of a defense attorney or a defendant. The question that we asked the jury, and they ultimately obviously got passed, is why the prosecution didn't call those witnesses.
As many have noted,
that's not how this works. That's not how any of this works.
I think what Devin's trying to say is that it's an odd complaint because the defense could have called those witnesses. Blanche, whose poker face is second to none, failed to remind his client, or maybe doesn't know, that both sides have subpoena power. So if there were witnesses who should have been called, Trump's own lawyers could have put them on the stand. Then Blanche headed to Fox to take a well-earned, victory lap.
Would you have done anything differently? Is there a witness you said, oh, maybe I should have called that witness. Maybe I should have done this?
Yeah, I don't know. I got to think about that, man. Like, we had a team. You know, my team is amazing. You know, the folks that work with us they're brilliant, and the president has a team, and they're brilliant, and we all did the best that we could, and I wouldn't change anything that we did.
So what happens next? Well, First, the defense and the state will each file a brief setting out their preferred sentence. Let's go out on a limb here and say that Trump's submission will have a big fat 0 on it. He's going to say that he did nothing wrong, that he's a first-time offender, that he's no danger to the community, that he's running for president, and that there is functionally no way for a probation officer, much less a prison guard, to supervise a man with a Secret Service detail. The prosecutors are going to say, not that. They're going to look at New York Penal Law Section 70, which sets out a maximum term of incarceration for a Class C felony at 4 years, but it gives the judge extremely broad discretion to do whatever he likes. And it seems pretty unlikely that the district attorney just spent 6 weeks in court with the goal of getting the defendant sentenced to probation. We'll just have to wait until June 13th to see what the parties request. The sentencing hearing itself is scheduled for July 11th, as per the request of Trump's lawyers. That did not stop Trump's son, Don Jr., from complaining that prosecutors had scheduled the sentencing 4 days before the GOP convention. They're not even trying to hide election interference. At the hearing, Justice Merchan will consider both sides' briefs, as well as a pre-sentencing report prepared by a probation officer after consultation with the defendant. The judge can consider Trump's behavior during the trial, including his 10 violations of the gag order and his clear lack of remorse. And while an elderly defendant with no criminal record would typically get probation, former prosecutor Diana Florence, who spent 25 years in the Manhattan District Attorney's Office, thinks that Trump stands a good chance of getting a custodial sentence. She told Politico, "Given the entirety of the facts and the circumstances that came out during the trial, I believe if convicted, a sentence of incarceration is warranted and justified." Once he's sentenced, Trump will have the right to appeal, and hello, of course he's going to appeal. He's already teed up challenges to Justice Merchan's refusal to recuse himself, as well as to a raft of evidentiary rulings and the court's denial of his motion to move the case out of Manhattan. The standard to reverse Justice Merchan will be abuse of discretion, which is a huge uphill battle. But even if Trump loses, those appeals will stretch well into 2025, and while it's technically possible that Justice Merchan could order him incarcerated pending appeal, it's highly unlikely that will happen. The guilty verdict will not stop Trump from running for president, though, and it won't even stop him from casting a ballot in his home state of Florida. Under Florida law, a felony conviction in another state makes a person ineligible to vote in Florida only if the conviction would make the person ineligible to vote in the state where the person was convicted. And under New York law, unless a person is actually incarcerated, they are eligible to vote. #rigged. But if Trump doesn't get his case overturned on appeal, he'll be a convicted felon, and that will have an impact on the pending criminal cases in D.C., Florida, and Georgia, because you can only cash that first-time offender ticket once. And in both Georgia and the federal system, he'll be ineligible for some downward sentencing departures as a repeat offender. Of course, if Trump gets reelected in November, he probably won't have to worry about any of that. But that is a problem for another day.
Yeah, by all accounts, this was a winnable case for Trump and his lawyers. It was never a given that the New York prosecutors would win this. But what about the performance of the defense attorneys in this case? Well, they didn't exactly nail it.
Nailed it!
One of the biggest mistakes was probably denying that Trump ever had an affair with Stormy Daniels. If Trump had conceded that he had had sex with Daniels, there'd be no reason for her to testify. But he denied it, so the prosecution had to call Daniels as a witness, and she told the jury about her harrowing encounter with Trump, and obviously the jury sympathized with her. Now, the defense also screwed up by attacking anything and everything about the case. Now, that's obviously Trump's personal style, and it might work in business and politics, but it doesn't necessarily work in a courtroom. Former prosecutor Renato Mariotti said in the New York Times, and I think he gets this exactly correct, the defense needed to tell a single story, which they could have, but didn't. Only Cohen was able to make the direct link that Trump personally directed the payments. And the defense could have laser focused on the idea that Trump was in the White House at the time and others like Alan Weisselberg were responsible and that the jury shouldn't believe Cohen. And the defense did attack Cohen, but they attacked every issue and witness with the same over-the-top histrionics and lost credibility and focus, which is not a good trial strategy. And they also probably made a mistake by not seeking a jury instruction on lesser included offenses that would have allowed the jury to find him guilty of misdemeanors rather than felonies. But you never guess any of this from the reporting on the case. What's interesting is that the Trump conviction has been covered extensively by over 600 news outlets, 37% of the reporting coming from the left and 21% on the right. But if you compare the headlines, you see some interesting frames emerge. On the left, you have outlets focusing on Trump's intent to influence the 2016 election, emphasizing political implications and the legal mechanism behind the charges. On the right, outlets tend to detail Trump's ongoing assertions of political persecution and interference. Now, usually these differences are subtle, but here they're pretty obvious, and they have a big role in how readers perceive the story. The first reports might relish the political victory, while the second set may leave open the question of the verdict's validity. And all this analysis is possible thanks to today's sponsor, Ground News, a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. Ground News gathers related articles from around the world and across the political spectrum so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. This can be especially helpful when reading stories from sources you've never heard of, which could be run by total nutjobs. And with the Bias Insights tool, it gives me a quick overview of the differences between left and right coverage. I also love their blind spot feature that shows you stories that are being underreported by either side of the political spectrum. It helps explain why we often talk past each other, and some people seem hyper-focused on what seems like nonsense, often because some random blog post went viral among certain people. But Ground News is my favorite way to get the news, and as a legal eaglet, you can save 40% off of the Ground News Vantage subscription by clicking on the link that's on screen or down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool and blind spot feed, and by subscribing, you'll support an independent news platform working to make the media landscape more transparent. So click on the link below for 40% off a subscription. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.